Hi guys, welcome back to my channel. This is Batok with Ola. My name is Mujalalu. Thank you so much for coming on the channel with me. Today I want to talk about holding brief. Holding brief is a phenomenon that occurs in law, in court, especially in litigation, whereby a lawyer stands in for another lawyer in court. Now, I don't think it's something that I've ever done, but I've seen a lot of lawyers do it, and some of them have got into trouble because of it. And that's why I want to talk about it, especially in the light of something that happened in court, recently with me and my colleague. And I want to talk about it because I know that the Supreme Court has decided that a lawyer holding brief is deemed to be properly seized of the matter, and so you should not announce your appearance as holding brief, but rather you should announce your appearance as the proper lawyer in that matter, because the court assumes. Now, I think that I jumped the gun because I've assumed that everyone listening to me or watching this knows what holding brief is, so I'm going to back up a little. Before I do that, it's been a really great day. Today, I went to the magistrate court for the first time since 2019, and I really had a sore time in court because I was trying to regularize our position in one of the matters at the High Court, and I needed to be at the magistrate court trial so that I could be able to understand the full position of things so that we can proceed at the High Court. So I went there today. It was really wonderful. I might do a video on that much later. Then today I got news that the additional grant that I applied for a client in one of the letters of administration that I applied for as far back as 2020 has been granted, approved. I'm so happy because it has been a long time coming, and this particular application has stressed me a lot. It's become a prayer point, so it's prayer answered. I'm so grateful to God. And thirdly, I'm so happy because today I finally concluded the mediation that I started in March. We had about 6 or 7 sittings. It's a land transaction, and I'm happy because we were able to execute an MOU, a memorandum of understanding, today, and both parties have gone away happy, and I'm happy as well. It's good news for me. So it's been a really great day, however hectic, but I still have to do this video before sundown because I think it's important for me to do it. Let's talk about holding brief. What is holding brief? Holding brief simply means that as a lawyer, properly called to the Nigerian bar, you are not the lawyer conducting a matter, but the lawyer conducting a matter cannot be in court on the day slated for proceedings or for trial or for litigation, what have you. So he has asked you to stand in for him. So you're basically standing in for your colleague at the bar, not necessarily taking over the case, but just standing in for him for that day. In most cases, it's just a one-time thing. That is what holding brief means. Now, holding brief has been ruled upon by the court as being unknown to our jurisprudence and our legal system. In fact, the court has held that any lawyer holding brief is deemed to be properly seized of the matter in which he is holding brief for another colleague, and so the court will address him, treat him, handle him, listen to him, hear him, as being properly seized of the matter. That is, the court assumes that you know what the matter is about and you want to carry on as the person for whom you are standing in would have carried on if he were around and in court that day. That's the position of the court. But the jurisdiction where I currently practice, I find that most lawyers still come to court and then they tell the court they are holding brief and they want an adjournment straight away. They're not even trying to conduct the matter. They're not even seized of the matter. Some of them don't even know what's going on. And I want to talk about this because of what happened to my colleague and I, most recently. And because the lawyer apparently did not know what had gone on in the matter. She was even lying. Because we are all male at the bar. So he was even lying to the court, probably unknowingly, because he did not know what happened or what had gone on in the matter. But of course, it was really embarrassing for him and for the lawyer that has sent him. So that's why I want to talk about it. There's nothing like holding brief in our legal system at the moment. If you're standing in for someone, the court assumes that you know what the matter is for and you're ready to go on. So don't ever go to court to hold brief with the goal or the assumption that you will just ask for an adjournment and the court would grant it. No, that is no longer the position. In fact, I don't think I've ever held brief for anyone. If anyone ever sent me to court, I went to court, I announced my appearance as the person in the matter, properly in the matter, and I carried on the business, whatever it was that they would have done if they were in the matter. That's what I always do, and I think that's the best practice. Now, if you're sending your colleague to stand in for you, ordinarily you should pay them. That's what I do as a lawyer at the bar. if you're sending your colleague to court, pay them so that they will do what you're supposed to do if you were in court. I'm saying this because I suspect that most lawyers come and, they just mishandle things for their colleagues because they were not paid in the first instance. Imagine someone had their own program for the day, you just call them and say, oh, please hold my brief in this matter. I know that there are situations when you can just, hijack them suddenly. Maybe they are already in court as well, or they're also in a matter in that jurisdiction or in that court or in the vicinity, and you just ask them to do you a favor. It could be. But if you're going to get someone to leave their office or their house to go to court for you, and that was not their plan for the day, you better pay them. And you better maybe hold a little conference with them for them to understand what they're going to do in the court and what the matter is about. So what happened in that matter was that, we were ready to go on, but the lawyer on the other side did not come. He had sent someone, so the person came and said he was holding brief and then sought an adjournment because he was merely holding brief. The court frowned on it because, the court said that it assumed, or he or she, is the court male or female, or hermaphrodite or whatever. So the court assumed that, they were supposed to know what was going on in the matter and come and represent whoever sent them, as they should, or as the person should have represented the client. But they were looking for an adjournment. So the court said we're going to go on, we should open our matter and then we should call our witness. So they decided and begged the court that they would be adjourning for cross-examination. Fine. So we went on. My colleague tried to tender a document, and then the court asked them if they would be objecting, which is normal. If you've watched my video on examinations, and how to tender documents, I've already talked about that. The court asked them if they would be objecting. They said they were objecting. On what ground? They said they were objecting on the ground that they were not the rightful counsel handling the matter, and that the other counsel would know so much about the document. That was embarrassing, because that is not a ground for objecting to a document. And clearly you could have, or you should have read the body language of the court and seen that the court was not willing to grant you an adjournment. So the best you could have done is to study, the document. Do you have any lawful ground? We all know the grounds, or maybe even if we don't, you can refer to the Evidence Act, the grounds for rejecting or objecting to a document. Which then is it the maker of the document? Does the person have sufficient knowledge about the document? So those are grounds, and some other grounds for tendering a document. Is it the photocopy of a public document? Has it been certified, or is it not certified? Like a certified true copy, so many other lawful grounds. But you cannot tell the court that you're objecting because you are not the counsel handling the matter and you are merely holding brief. No. So what's my advice here? If your colleague is asking you to stand in for them in a matter, and there's no luxury of time for you to prepare adequately for the matter, or to prepare your watna and your batna, you better do not stand in for them, okay? Do not think you're doing someone a favor and then go embarrass yourself. It's not the best, because you don't know who's sitting in court that day. Maybe your next client is sitting in court. They're looking at you as incompetent. They don't know that you are really competent, but this came to you as a shock, as a surprise. Your colleague sprung a surprise on you and you were trying to do a favor. No, it doesn't work that way. Or if a colleague is asking you to stand in for them, then if there's adequate time, try to do a pre-trial, conference with them. Maybe a phone conference, maybe a physical conference, just to get up to speed about what the matter is about and what you had to do in court on that day. It's very important. A lawyer must not be caught unawares and must not be set up or set himself up for embarrassment. No. So that's what happened in court, and that's why I thought to talk about holding brief. Usually, if you're holding brief, this is how they announce their appearance. May please the court, Houseoflivingstones, holding the brief of A.O. Mushobalaje for the plaintiff. S.K. Mushobalaje is my very good friend, senior friend. Your name just came to my mouth. Sorry. Or you could say, may please the court, Houseoflivingstones, for the defendant. My lord, I'm holding the brief of K.A. Davis. Okay, so yeah, you could say that. And when you start the case, you tell the court that, oh, the counsel in this matter is indisposed, the counsel in this matter is this or that. Depending on what you tell the court will be able to decide if you are in the proper place or rightful position to seek an adjournment, and if it will grant an adjournment or not. But do not ever go to court to hold brief banking on an adjournment alone. I've talked about Watna and Batna on this channel. Please go watch the video I'll leave a link to it in the description box. So please, it's very important. Prepare ahead if you're holding brief. And really, nobody holds brief anymore. They still do it in this jurisdiction like it's the normal thing. They do a lot of funny things in this jurisdiction anyways. But what I'm saying is nobody holds brief anymore. The court has decided, the court has ruled that any lawyer holding brief is deemed to have been properly briefed about the matter, to be properly seized of the matter, to have adequate information and understanding of the matter. And so the court will treat you as if you are the one, handling the matter. So you must be prepared. You must be prepared. So that's what I want to talk about. Even if you're holding brief, which you shouldn't, please get your partner and your partner ready. And don't go object to a document on the ground that you are holding brief. That is not a ground known to law. The court had to ask the lawyer, how old are you at the bar, and all of that and all of that. It was really embarrassing. It was really embarrassing. So it's nothing that any lawyer should experience. And I do not blame her. I do not doubt her competence. I just think that maybe her colleague put her in a bad spot, or her colleague sprung a surprise on her, or maybe she thought she could wing it. It could have been anything, but that's how it played out in court. So please don't go to court to hold brief. And if you're holding brief, do not bank on an adjournment. Make sure you're ready to do what the counsel in the matter would have done if they were in court, because the court will and might decide to treat you just that way. That's all I have for you in this video. I will see you in my very next video. Toodles.